Okay, moving forward, we got to our last presentation, and we're moving on to the new section of environmental law. So this is going to be the Railroad Environmental Legal Update from Theresa Romanovsky with the Association of American Railroads. And Theresa is the Assistant General Counsel of the Association of American Railroads. She holds a BA in Environmental Studies from the University of Pittsburgh and a Juris Doctorate from the University of Michigan Law School. Her main focus at AR is on environmental legal issues impacting the rail industry. So the last presentation, but not the least. So thank you, Theresa. All yours.
Thanks, Brian. Can you hear me?
Yes, we can hear you.
Okay, great. So I have the much coveted very last spot of the conference position, and then I also get to follow the guy with a video of an explosion. So no pressure, tough act to follow. I just wanted to give you guys a couple of updates on some federal laws that have been changing and that are in litigation over the last year. So here's a quick agenda. We're going to talk about the new NEPA regulations, the Section 401 Clean Water Act regulations, or the rule, LNG by rail, WOTUS, and then I'll bring to your attention a few other legal items that we're keeping an eye on, but I won't spend too much time on that because A, we're running out of time, and B, I think Bob covered a lot of them yesterday. So first up, you may know that earlier this year, the Council for Environmental Quality, or the CEQ, which is a part of the White House, issued the first new NEPA regulations to be released in more than 40 years. It was the early 70s when the regulations were last updated. AAR and many, and actually about 1 million other people, literally, submitted comments on the proposed rule, and EPA and CEQ quickly went through and addressed those comments and released the final rule, which is now effective. A couple of highlights. Obviously, these are new NEPA. The statute is pretty straightforward, but the regulations are actually a bit involved. So I'm just going to highlight 6 main points that you might want to take away from the new regulations. The new regulations eliminate cumulative effects analysis, and it revises the definition of effects. So effects are now defined as changes to the human environment that are reasonably foreseeable and have a reasonably close causal relationship to the proposed action or alternatives. So this basically eliminates the need for project proponents or federal agencies to consider impacts that are geographically remote. So think about impacts way downstream, outside of an airshed, outside of a watershed. Those impacts under the new regulations likely do not need to be considered. And it also likely, although we'll see how it plays out, the intent on this new definition was to exclude climate change effects, so that project proponents and federal agencies no longer have to explain how their project is going to impact the climate. And that's probably useful to the rail industry because, at least in the pipeline industry, they were really getting hammered on downstream effects of the combustion of their product that they were shipping on climate change. So those effects were basically being attributed to their new projects or new pipelines. And you could imagine the same thing being true for railroads. If a railroad is transporting a fossil fuel or coal as a common carrier, those effects from the combustion of those fossil fuels should not be attributed to the rail industry. So I think this is a good change. It also redefines major federal actions. And basically the outcome of that is that it for smaller projects, or for projects where there's only perhaps one federal permit required, those would no longer be considered major federal actions that would trigger NEPA and require an environmental analysis to be completed. A third highlight from the new regulations that it limits the timeline for agencies to complete their environmental reviews. Probably many of you have experienced a situation where your NEPA process goes on and on for years. This this change limits it to 1 year for an EA or 2 years for an EIS. There are exceptions, but it provides a nice guideline. And in effect, this is codifying what the FAST Act and one federal decision were trying to accomplish. As I just said, it kind of codifies the one federal decision policy, which directs agencies to cooperate more together, to issue a single record of decision, a single EIS, and to cooperate to accomplish the completion of the environmental review within the 2-year time limit. It also directs agencies to consider environmental trends. So for practical purposes right now, the affected environment includes reasonably foreseeable environmental trends. And this is another way that CEQ was trying to remove the requirement from federal agencies that they consider climate change as an effective or proposed action. And finally, the new regulations limit the scope of the alternatives that need to be considered. Before, you would have a lot of projects, especially if it's a privately funded project that requires federal permits, a lot of times courts would require agencies to consider alternatives that didn't actually accomplish what the private person or the private entity who is providing the funding for the project it wanted to accomplish. And so this requires that the alternatives a federal agency only need to consider a reasonable number of alternatives, and those that are economically feasible and that meet the purpose and need of the proposed action, and where applicable meets the goals of the applicant. And so that means that for railroads, if you're working on a project that maybe happens to be on BLM land, but you're financing it, this is a good beneficial change for our industry. The revised regulations went into effect on the 14th of September. Perhaps not surprisingly, 23 states have already challenged the regulations, and several environmental groups have filed challenges. Many of those plaintiffs, the states and the environmental NGOs, asked courts to enjoin the effective date of the regulations. And as of today, all of those federal courts have declined to do so. So these regulations are in effect for all new projects that are started, and I guess we'll keep tracking the status of the various cases that have been brought. Next, we'll talk about the Clean Water Act Section 401 water quality certifications, and I kind of joke that this is for any law nerds out there, this is adventures in cooperative federalism, because prior to this new rule, each state kind of had a different perspective on how they approached the decision of whether or not to issue a water quality certification. Some states just did it as a matter of a technicality. They just kind of stamped an okay on it and moved it through. And other states had gotten in the habit of basically holding up any infrastructure project that they didn't want. And that would put projects on hold for literally decades sometimes. So the new rule, well, and just to back up, Section 401 of the Clean Water Act allows states to issue what's called a water quality certification, and a lot of federal permits are dependent on the project receiving that certification. And basically what that's supposed to do is say that the project isn't going to negatively impact the state's water quality standards. The new rule, it narrows states and tribal authority to halt or stall projects, and basically offers more deference to the federal agency. Again, the rule went into effect in September, but 20 states and the District of Columbia have already filed legal challenges. The two main key takeaways that I want to bring to your attention from this particular new rule is that although this likely makes it a little bit easier to obtain a water quality certification from the state or from a tribal government, the project approval is not guaranteed. because states and tribes can still deny permits. They just have to do it more quickly, and they have to base the denial of those permits on a negative impact of their water quality standards. So for example, a state can no longer say, we aren't going to permit this project because that rail line is going to carry coal, and coal contributes to global warming. A state can't do that, but they could say, this project is going to result in a degradation of our water quality, and therefore we aren't going to permit it. It should provide clarity to project developers and project proponents, and it should provide an answer within a year, which is one of the things that's required under the rule. The next thing I just wanted to mention was the LNG by rail rulemaking. As many of you probably are aware, until recently, liquefied natural gas, or LNG, was excluded from the list of commodities that were authorized for rail transportation. And most of this was due to nothing more than a lack of interest in transporting LNG. However, increasing domestic and international supplies of natural gas and demand for natural gas have changed this dynamic. In addition, most natural gas is shipped via pipeline. And for those of you that follow the environmental news, you probably know that most of the major pipeline projects that have been proposed and that companies have attempted to develop over the last decade have met with pretty major legal challenges and snafus. And so the ability of the prospect of new natural gas pipelines is pretty low. And so a lot of folks in the natural gas industry are looking at alternative ways to ship their gas. In 2017, AAR asked PHMSA to create a rulemaking that would authorize LNG for transportation in DOT 113 tank cars. And basically, AAR pointed out that, that the rail industry already transports a lot of hazardous materials. It is safer to do so on the rail system than it is over the road. And highlighted the fact that demand for natural gas within the United States is increasing, particularly in New England. So the final rule amends 49 CFR parts 171 to 180. It allows the transport of LNG under certain conditions. Basically, it's a modified DOT 113 tank car. The tank car has to have a 9/16 inch outer tank, and it has to be made with a particular kind of steel that is more resistant to punctures. The rule also requires enhanced braking, remote monitoring, and route analysis. And here are just some of it's a comparison between some of the special permits that were issued, the notice of proposed rulemaking, and then the final rule. So this is right out of the Federal Register. As you may not be shocked to find out that the LNG by rail rule has been challenged by several states, several environmental NGOs, and those cases are currently proceeding in the DC Circuit. AAR is obviously keeping a very close eye on that litigation, and we're looking to see what happens. However, the rule has not been enjoined, so it is in fact in effect right now. Mostly, the waters of the United States under the Clean Water Act is important for a lot of you, depending on probably your 404 permits from the Corps. That might be where you most frequently run into issues with the WOTUS rule. The Trump administration released the final Navigable Waters Protection Rule that was effective in April. It includes a ditch exclusion that encompasses most irrigation and drainage ditches. And although it wasn't actually listed in the final rule, the preamble to the rule states that this exclusion encompasses most roadside and other transportation ditches. Also excluded are groundwater recharge, water reuse, and wastewater recycling structures, including detention, retention, and infiltration basins, and ponds constructed or excavated in upland or in non-jurisdictional waters. And so basically, because of these exclusions, a lot of what would have been considered waters of the United States under the prior rule will no longer be considered a water of the United States and won't require a 404 permit. And as I'm developing a pretty common theme here. Most of this rule is also subject to several challenges and is involved. Parties are involved in pretty intense litigation right now. And I'll just leave this. I know we're running out of time, so I'll just leave this in here. Bob talked about most of these yesterday, but if you have any questions on them, please feel free to let me know. And in the interest of time, I will wrap it up. Does anybody have questions for me?
It looks like we've got one question. How long after November 3rd do you anticipate these regs to be repealed?
Well, it might depend on the rule. Let's see, the NEPA regulations, I don't see those being repealed. I think most people would agree that that the NEPA regulations needed to be updated, and that NEPA litigation was, quite frankly, getting completely out of hand and consuming a lot of federal and private resources. Let me see. I would not be surprised to see the Clean Water Act 401 rule rescinded, just because a lot of states just are very, very unhappy with that rule. And the legal basis for that rule is a little bit more questionable as well. WOTUS, I have no idea. I just don't know. And the LNG rule, I think because PHMSA has already issued special permits for LNG by rail, and so it's already happening, I guess I just don't see that being a focus of a new Department of Transportation secretary. But I don't really know. I guess some of those are more clear cut than others. I think NEPA and LNG by rail, those two seem to be on pretty good footing. Yeah.
You know, I wonder if one possible outcome of the LNG by rail is, you know, the outcome of this this National Academy study.
That it's if I remember correctly, the National Academy study found that there was no increased risk from transporting LNG. Is that the one you're referring to?
No, there's a new one. Bob Franzak spoke about it yesterday.
Oh, okay.
Maybe, yeah.
All right, well, if there's no other questions, that concludes the afternoon portion of our presentations today. So thank you very much for the presenters. And Josh, thank you very much for handling all the questions. And I will turn it over to Emma and Chris. Thank you.